Vodafone, Flipkart, Swiggy, and Cardecco. Then we have Dr. Lazar Redick. Lazar is a senior scholar for competition policy at International Center for Law and Economics. He is also adjunct professor of law at IE Law School, Madrid. Then we have Mr. Ram Kumar. Ram is a senior partner at AZBN Partners. He has over 15 years of work experience in the field of antitrust, where he has advised clients across diverse sectors such as tech, media, pharma, petrochemical, oil, gas, and FMCG. Then we have Laila Norakis. Laila is a senior policy analyst at the Schumpeter Project on Competition Policy at Information Technology and Innovation Foundation. Her research focuses on international antitrust law with a focus on digital platforms. Laila previously served as a senior counselor at the Hungarian Department of Justice. Then we have Mr. Vineet John Samuel. Vineet is a doctoral candidate at the Hertie School, where he studies economic and social impacts on the platform economy on developing nations. He is presently Director of Public Policy at the Institute for Sustainable Development and Governance and a Fellow at the Center for Competition and Economics. I would like to thank the panelists for accepting the invitation on such a topical issue. Just a brief background to the discussion we are having. As mentioned in the start, we have this report known as CDCL, which is Committee on Digital Competition Law, which has basically released a report along with a draft competition bill 2024, in which they have suggested some sort of ex-ante rules, which would be applicable on digital markets in India. Now, with that background, keeping that background in mind, I request the panelists to open the discussion with their opening thoughts. Along with their opening thoughts, I would also want the panelists to cover, what really sets digital markets apart when compared to brick and mortar economy, both from an innovator perspective as well as from a regulatory perspective. The lineup which we can follow is, we can start with Panduranga, we can then go to Lazar, then Ram can follow, followed by Laila, and then followed by me. So Panduranga, over to you. You can unmute yourself and please come.
Hi Sumit, thank you so much for this opportunity, and also welcome everyone to this interesting conference, and most of you from different jurisdictions too. So good morning and good afternoon for many of you. It's an interesting question. In the pretext of this digital competition law, the upcoming law, it's a good questions to ask as to what's the digital markets apart from the traditional brick and mortar. I think the access to wider market presence, which is essentially more than what a brick and mortar could ever envisage to have a business as, and then cost reduction in terms of the setting of a business and going live and fulfilling customers' orders at very cheaper cost in terms of capital, and then convenience. They'll be able to give greater convenience to customers, which is a doorstep delivery, which is generally absent in case of a brick and mortar. Beyond that, the range of products availability, it's like making choices, and then lastly the better pricing in terms of convenience is concerned. And then probably be more than this is personalized shopping experience, where you may, like in the digital market, can expect that a supplemented product choices, what has been otherwise complemented such purchases, right? Someone who's buying a fishing net, maybe also be told you can also buy a fishing rod, for example. And then it is also liked by these new generation consumers, because they also want things to be at speed and at convenience, and people like doing things in a digital way, because all of these factors, and most importantly, when I say why they like it, because of this convenience. Secondly, convenience of making payments, right? And also, like you know how the laws have evolved from the introduction of internet till today, introduction of Information Technology Act, and there are several other amendments followed by the Information of Technology Act in India and elsewhere as well. They have also created a conducive environment, right? So that conducive environment help flourish these digital markets, right? It could have been very difficult 10, 15 years ago to buy or book a air ticket, oh, right, for a travel, but now that is possible in a minute. So that's my initial thoughts, Sumit.
Thank you so much, Panduranga. Now I turn to Lazar. Lazar, I think Panduranga has very well sort of spoke on the innovator side, and that makes a lot of sense because I think uh, Panduranga is currently working as one of the top performing startups in India. So
I
Lazar, if
know.
you can, yeah, yeah,
He's
over to
famous. I
you.
know. Yeah. Honored to be here with him and with
Yeah,
everybody else. Yeah.
yeah.
Sorry. Go ahead.
Yeah, so Lazar, if you can give your opening remarks along with what sets digital markets apart, both from an innovator perspective as well as the regulator.
Yeah. Well, Panduranga has made great, opening remarks as to, what separates these markets from other markets. I have slightly a more provocative view, which is that I'm not even sure that there is such a thing as digital markets that are separate from other markets. If you look at the definition that Digital Markets Act gives of a digital market, assuming that we take that as a valid source, it is a ragtag of products, right? Core platform services are in themselves very different. Voice assistants are, vastly different from, say, e-commerce platforms. So, these goods and services are very heterogeneous amongst themselves, on the one hand. On the other hand, I'm not entirely sure that they have characteristics which separate them, so clearly from other markets. If what makes a market digital is the use of data, many markets use data. Banking uses data. Brick and mortar shops use data. It's hard to think of an industry that doesn't use data. So maybe what I can say as my opening remark is what caught my attention in the draft competition bill and the report that accompanies it is that it kind of seems to go back to what India had before the Raghavan report in 99, if I'm not mistaken, and then the Competition Act 2002, which was the 1969 Monopolist and Restrictive Practices Act. Now that act was very structural. It limited, it obliged certain companies that had a size or had a turnover above, I don't know exactly the number in crores, but a substantial number, to ask for permission for every subsequent acquisition. It was the point of the Raghavan report was to install a more economic approach to India and to move away from that structural paradigm, right? So that actually aligned India with the US, with the European Union in the more economic approach. And it was consecrated in the Act of 2002. Now, what we're seeing with the the draft digital competition bill is sort of a return to that paradigm. It's targeting certain companies based on size. It levels down those companies, makes it harder for them to use their scope and size and to acquire it, and discourages companies from acquiring scale, in my opinion. And all of this is based on a concept of fairness and contestability. And if you read the report says that actually Indian competition law is about fairness and contestability, which is literally the opposite of what the Raghavan report said. The Raghavan report said that fairness is not a good goal because fairness is hard to quantify and it's contrary to efficiency. So from an outsider's perspective, it's interesting to see this and to place it in the historical context of what it means for the development of India's, competition law and trajectory. That's my opening remark.
Yeah, thank you so much, Lazar. I think these are some great insights. Ram, I come to you. What are your thoughts on this?
Thanks, Sumit. Thanks for having me with such great panelists here. As Pandu said, the context, trying to kind of describe what the digital market today is, and what is the difference between digital markets and traditional market. And I completely agree with the points that Lazar just made. We are just walking backwards towards the more prescriptive MRTP regime. I completely agree with him. That said, I think trying to kind of merge both these perspectives that my previous speakers have kind of put on the table. What are we looking at? We're looking at a law which tries to identify a set of services as problematic. I think the first question is, before adopting a prescriptive carte blanche sort of an approach, there is a necessity for us to identify what are the holes that we're trying to fill. What is the gap, perceived gap, that this new law is going to fix? That's the first question. And unfortunately, in the report and also the legislation, the draft legislation, this aspect is completely missing. What appears to me, and I'm sure most of our panelists would agree with me on this aspect, is uh, the committee has gone basis the CCI's past investigative history and what precedents are available, and chosen these areas and assumed that any action taken by the Competition Commission, orders passed by the Competition Commission, has been ineffective, which is a huge assumption to me, right? There are areas where the Competition Commission is a very robust authority, which has been doing a phenomenal job for the last 15 years. And to kind of assume that the orders passed by the commission is ineffective and it has not had an impact in changing the dynamics, right? Wherever there has been a breakdown in whichever market, is a huge assumption. And secondly, as far as putting on the crown made of thorns, SSDE, right? And the part that kind of baffles me is, A, there is a quantitative threshold that has been carved out. And clearly these quantitative thresholds are, I mean, the whole ex-ante approach has been inspired by what DMA is doing. That aside, the quantitative threshold is pretty low for an Indian standard, right? Why do I say this? Because you have a lot of small startups that are up and coming, right? The internet revolution in India is hardly 7, 8 years old, right? Thanks to cheap internet, which has been available for us from 2017. And if you were to kind of rewind 10 years ago, and some of the panelists with gray hair here would agree with me, 10 years ago we used to pay almost 400 rupees for 1 GB of data, which is quite exorbitant when compared to what is happening today, right? So the internet revolution in this country is pretty new, right? And only a small fraction of the Indian population has had the benefit of digital products, right? You're looking at a population of 1.4 billion, right? And there are so many digital products that have not reached the nook and cranny of the country, right? If you were to apply the low standard and low threshold that has been kind of considered and kind of put in paper by the committee, you would catch a lot of smaller startups that have not reached global scale. And India has a lot to offer in that, from that standpoint, and that is a huge issue according to me. And what the draft legislation seeks to achieve is to kind of foster innovation, and this is likely to kind of stifle innovation, and it will create disincentives for companies to kind of enter. And more importantly, some of these startups, I mean, you have very rarely you have promoters with significant money stepping into business, right? You need capital, right? And the capital is going to come from venture capital investors and private equity investors, right? If there is going to be significant uncertainty as to when this crown is going to fall on your head, right? There is a great disincentive for private equity players to step in and finance. So to my mind, as Lazar has rightly pointed out, we going backwards, and I don't think India, the place where we stand today, we do need a separate regulation for an ex-ante regulation. And the need of the hour is, A, strengthening the CCI with whatever structural strengthening that is required, And if there is a need to fill in certain gaps, that those gaps will have to be filled in the current law after market testing. Market testing is the most important thing. Without understanding the lacuna in the particular law, you cannot fix. I mean, unless and until you find the problem, you can't fix it.
Yeah, thank you so much, Ram. I think these are very detailed comments. Now I go to Laila, followed by Pete.
Thank you. Good morning, good afternoon, depending on where you are. Thank you, Sumit, for the kind introduction and also for having me here today on behalf of the Information Technology and Innovation Foundation. I apologize for my voice. We just had a panel 2 days ago about India's digital competition law, and I'm so pleased to see that this Indian proposal receives due attention within the broader international community. I would like to address this question from a slightly different angle. When, why, and in what cases does jurisdiction need new laws, right? I agree with the previous statements about the differences between brick and mortar and digital companies, digital markets. Of course, there are objective differences between these markets, but there are plenty of studies that cover these and also the network effects of the two-sided markets on the digital economy. However, what very few cover is that the growth of two-sided online marketplaces does not itself justify reforming antitrust laws. So regulators can use existing analytical methods to distinguish anti-competitive conduct from pro-competitive conduct. So from a regulatory perspective, legislation in the digital markets should be based on market failure. First of all, the regulation in the digital sector is only necessary if it remedies market failure and if the existing legal framework is incapable of providing solutions for this problem. Here, I have to mention that the Indian practitioners also highlighted, including the Competition Law Review Committee within the Ministry of Corporate Affairs, they already evaluated the status of competition law in India between 2009 and 2019, and they held that the current provisions of the Competition Act of 2002 are sufficient to address competition aspects in the digital markets. With this, I would like to turn to the other half of the first argument, that is the regulation in the digital sector should be necessary to cure market failure. However, in the case of India, market failure does not appear to exist in the digital markets. On the contrary, India's digital markets and really India's digital sector is kind of dynamic and growing with the rest of its economy. To give a data point, India has startup figures comparable to the US, and about half of its overall unicorns achieved status in the last couple of years. In addition to this, one of the core arguments of regulation in India, according to the report, is that ex-post enforcement takes very long time. Therefore, it is not appropriate. However, it does not address any alternative approaches to cure this administrative insufficiency. So they could build capacity within the current regime of the competition enforcement instead of changing the whole legal regime. Moreover, the report emphasizes that the proposed regulation can be complementary to the ex-post enforcement, but it didn't explain how this could happen. However, neither of these arguments answer the key question whether ex-ante regulation is going to improve upon the status quo or whether the reduction of administrative costs, including the remedying anti-competitive behavior, more quickly is going to outweigh the error costs that will result in the regulation itself. So the report does not justify the significant changes it intends to introduce. Introducing such ex-ante system in the emerging marketplace could have unintended consequences. But let me stop here at this moment.
Laila, are you done? Yeah, thank you so much, Laila. I go to Vineet now. Vineet, if you can share.
Thank you, Sumit, for having me here today. I hope you guys can hear me.
We can hear.
I quite liked some of the statements made earlier, both with reference to the act and with reference to digital platforms in general. I tend to sort of agree on a lot of key points, but there's significant points of departure. But for now, I think I'll just limit myself to where we are. I mean, where the consensus is on the distinction between, say, digital platforms and brick and mortar industries. And I think the top three, I think the easiest way to sum it up would be the first, which has been mentioned, which is the network effects, especially in two-sided markets and so on. Primarily that, the value to each user increases as more people use the platform. But I think this also entails, three further subpoints, which is that after a point when you scale, the customer acquisition cost continues to drop to the point where marginal cost actually comes down to near zero for certain industries, as opposed to brick and mortar industries where this usually isn't the case. What also ends up happening is that because of the initial sort of investment size, especially as is the case with large tech platforms or platforms looking to disrupt certain sectors, you end up, because of the tendency, this natural centralizing tendency and network effects, you end up having a handful of players who end up sort of splitting the market between themselves. Also, I guess for tech platforms, another key point is that there are data network effects which don't really apply to brick and mortar platforms. Primarily that, platforms with first mover advantages often collect a significant amount of data. A lot more data than others, and they can hence improve or train their own data, algorithms to be competitive in a manner that other platforms can't compete with. I think this has sort of been flagged in a lot of EU cases as well, if it just on issues of, say, ranking, prioritizing your own your own products on your own platforms and so on. And finally, the point that in a lot of cases, certain tech platforms become key infrastructure on which their competitors also have to operate, like, say, Amazon with AWS and so on. So, these are some of the noted sort of distinctions that have been leveled in, either legislation or judgments across jurisdictions over the last couple of years. So I think that is important. Just to highlight that distinction. Now, coming to the bill itself, it is interesting primarily because of the distinction that did you have? Can I continue, Joanne? Okay. Yeah. The distinction between, I think, the two opinions that the ministry has, which is that there is no need for further strengthening of the Competition Law Act, and the standing committee's notes on the 10 violations which you need to sort of be addressed. Now, whether this act really goes around and this draft bill is the best way to go about doing it is a secondary point. And I think we're only going to find that out after it's implemented. But I believe that there are certain points which are to be noted, and they've been raised by speakers earlier as well. I think Lazar raised it in both in terms of what he said as well as what he has written, I think, for ICLE regarding the possibility for rent seeking, especially because, as Ramkumar pointed out, it's like a crown of thorns which can be placed on certain corporations' heads and so on. And it can become a tool for rent seeking, primarily because the government decides that you in particular are, an SSDE. Second, I think that there is a lot of merit to what Leela said specifically with regards to the complementarity. When they say that this is to be ex ante, they don't really establish how it's going to be complementary to the existing piece of legislation, which they will have to sort of map out in detail. And yeah, I think that really leaves a lot more to be desired on the bill side. But finally, I also think that it does expand the scope for what how we understand consumer welfare and whether that is to be the only good. And in that sense, I guess it's similar to the MRTP, because when they talk about fairness, it talks about another principle which they want to prioritize as opposed to just consumer welfare. And I think this is interesting because it allows you to expand the scope of what all the Competition Commission should look at, if not just consumer welfare, or it allows you to expand how we should interpret consumer welfare. I think this has become a standard, not just in, this has become a standard with, Lina Khan at the FTC. It's become a standard in the EU as well, just to expand the scope of how we understand consumer welfare, whether we should want competition for competition's sake, or are we just looking at, short-term advantages to the consumer in terms of price? So I think the bill really opens up the scope for that discussion. So in that way, it's good. But just in terms of the nitty-gritties and like how it's operationalized, how it could be misused for rent seeking, and so on, I think they should really be clear on that. In terms of the quantitative threshold, they should. I believe I agree with Ramkumar that it should be increased as well. I'm more concerned about the qualitative side, because they have a scope for, even if you don't reach the quantitative threshold, you can still be classified as an SSDE if the qualitative requirements you somehow fulfill. So I'm more interested in how they define all of these, and perhaps that can be ironed out. But I suppose that's why we have a draft, and that's why they invite comments. But yeah, thank you. That's it from my end.
Yeah, thank you so much, Vineet. Before I move forward, I request the participants, in case they have any questions for the panelists and who are on this call, they can just mention that in the chat box, and I'll be happy to take them up in the last. Now, moving forward to the discussion, Pandu, I again come to you. And I mean, a lot has already been said in the opening remarks itself. Like, I mean, what this law seeks to do. I want to understand it from you. I mean, how Indian tech is perceiving this bill, and given the objective of the law that there are apparent network effects, all it is less marginal cost as you expand and so on and so forth. What is the larger stand of the Indian tech, or if, so as to say, not the Indian tech, but what Indian startups have to say on that, and how much the law and how far does the law go in addressing the stated goals, both the pros and cons of the law proposed law.
So see, I think there are a couple of different viewpoints, right? We have few startups who have been been suffering of few decisions of big tech companies, who have to heavily rely on those big tech companies. On the other hand, you have big tech companies, and there are few other companies who are working in hand with big tech companies as a matter of their business. So you will generally find different viewpoints which can work against each other as a dichotomy. But broadly, if you look at the underlying perception for this particular legislation is ex ante versus ex post. Now, it is lack of patience that anyone who have been affected wanted to pursue with those big tech companies. They found it like very difficult for them to pursue, and they also found it like taking steps. Should there be any reason why would they go to the CCI? If the CCI were to ever take action, should there be a ex post situation arisen already, or is it an ex ante case? Now, whether such actions have committed by big tech companies would amount to adversely affecting competition are like abuse of dominance, it is etc., etc. So broadly, I would say situation is such that people are not in favor either nor against it, but there is a segment which is in favor of this bill because of the reason it is ex ante. There are few are not okay because for different reason, right? But it is completely different, choice of preference from legal position. If you look at legal position, again from a legal position, if there are set, segment would think the current competition law itself is more than sufficient to deal with any digital market related issues. But there is another segment would feel like it can be a good one when there's an expo situation, but not for ex ante situation. And as we all know, Indian Competition Commission or Indian competition regime heavily draws inspiration from US market, UK market, right, and UK legislations. And therefore, probably you might see this is just an inspiration drawn from the UK recent digital market.
Yeah, thank you so much, Pandu, for sharing your thoughts. Now I come to Lazar. I think Lazar, you had an interesting thing to say, and there is a question also we have from Anish, who has specifically raised this point that you mentioned that data has been common since the very start, right? So I mean, obviously, the first question is, what are your views on this law? I mean, I have read the article which you have written on this. But I mean, one could also say that the ship has already sailed, in the sense that parliamentary intent is already now very clear, both through the standing committee and what the CDCL has said. So I mean, if given we assume that this law would ultimately be enacted, what would be your suggestions moving forward? And specifically, if you could cover, I mean, would this law also be applicable on various sectors, such as fintech, banking, financial sector, as you already pointed out? And how would this whole concept of core platform service would be applicable on them?
Okay, so the two questions are, maybe the last one is whether the approach in the digital competition bill could be expanded to other sectors. Is that right?
Yeah, so I mean, how would this entire ex-ante regime or the idea of core platform service would be applicable on, let us say, banking companies in India? Because the whole idea of SSDs is around quote unquote big tech, which are basically the gamma firms, right, or whatever you call it. But what about these insurance companies, banking companies, who have also been working in the data analytics in the larger sense?
And the other question was, if this is an inevitability, how could we improve it, right? Okay, maybe let's start with that one. So I guess my biggest criticism of the European Union's Digital Markets Act, which is a great part of the inspiration of India's approach, is the blunt approach that it takes. So there is no requirement to show any sort of consumer harm, or in fact any harm, to intervene. The Digital Markets Act takes certain conduct and either prescribes it or prescribes it. It either prohibits it or obliges it. This is very different from the approach that we followed in antitrust. And here we go back to the whole argument about taking steps back. The approach in competition law has been to prove economic effects, especially effects on consumers, before intervening. And as economic sciences developed, we have come to realize that certain conduct that we thought was always bad actually might be more competitive, right? Such as resale price maintenance. Since 2007 in the US, since the Legion case, the Supreme Court said, well, this can actually be good to help companies penetrate new markets and to strengthen interbrand competition. The approach of the Digital Markets Act is much less skeptical of the regulator's own knowledge. There's a lot more hubris from that perspective. The regulator says, we just know this is bad. We know that this is bad, or we know that this is good. No analysis is necessary, and no exemption should be available to the gatekeepers. So one thing that I would do to improve the Digital Markets Act, or India's version of it, if it's absolutely inevitable, which I guess this is a political question that you can tell me that I don't know myself, I would incorporate some sort of either need for the regulator to prove harm. It could be an abridged version of it, and there could be a burden shifting framework where then the defendant shows pro-competitive benefits, or there's a reversal of the burden of proof, like in the UK, as long as there is a way to argue that actually in this case, this doesn't harm efficiency and this is pro-competitive, right? So we've seen that Europe doesn't do it, but we've seen that UK already did it slightly, and the latest amendments strengthen that. Now, in my view, it's imperfect because the burden of proof for the gatekeeper is high, and the burden of proof is being reversed, in my opinion, unjustifiably so. But okay, I guess it's less bad. And South Korea recently came out saying that they were going to enact their own digital, version of the Digital Markets Act, but they were going to look at proportionality and how it affects consumers before intervening. That's already a step in the right direction. I would just leave it at competition law personally, but if this has to happen, you have to sort of prove harm. These are not conducts that are unilaterally harmful. And if they were, why not just ban self-preferencing everywhere, right? So this is how I would improve it. As far as the second question go, if I understand correctly, and also there's a question in the chat that maybe relates to this, if that's the one that you're referring to.
So I'll be posting this question to Ram. So
yeah. So the thing is that in India, the Digital Competition Bill would be an amendment, right, to the 2002 Competition Act. It wouldn't be a separate law like the DMA. My sort of concern with that is that the approach of the Digital Competition Bill differs from the approach in competition law. The competition law is guided by consumer welfare. That's how we tell whether conduct is competitive, in the sense that, well, let me just take a step back. Antitrust deals with the central question of whether market behavior is pro or anti-competitive. Now, it's hard to tell the difference because the observed outcome is often the same. A competitor leaves the market. But of course, that could be good or it could be bad. It could be good if it's the result of competition on the merits of a better product or consumer choice. And it could be bad if it circumvents those things, if it's actually, it does so by restricting competition. But this doesn't apply to the Digital Competition Bill. So my concern of incorporating the Digital Competition Bill as an amendment, and I would say the same thing of the Turkish or the German amendments that are also amendments to the act as opposed to separate legislation, is they could end up influencing or polluting, if you will, the quote unquote purity of the competition law system. So the decisions that have been taken in the digital markets, so to speak, could end up serving as a precedent to other markets. And it could end up engulfing or englobing other sectors and other companies that are not just those that are currently covered by digital markets, by the Digital Competition Bill.
Yeah, thank you so much, Lazar. Now I come to Ram. So Ram, there are two things which you said, like which is, the presumption under the CDCL is that CC has been ineffective, and this entire theory, this entire concept of SSDs. So there are two specific questions for you I have. One is what Aditya has mentioned in the chat, that would amending the current law would have been a better alternative than going for a totally different law at the very, then going with a totally different law. The second thing which you pointed out is regarding the threshold. What are your thoughts? Because in the EU law, there is a question from Anish which mentions that there is this 10% population has to be covered. On the contrary, in Indian law, the threshold is just 1 crore. So why this departure? And there's further question from Mayank and Alvira, which is related to your CCN being an effective part. That does India have
one after the other? Sumit, let's take one by one.
Yeah, sure.
Thank you. On the first one, whether it should be a separate legislation or it could be an amendment to the Competition Act, to my mind, that's form over substance, because the intent of what is the intent of what should be the direction of the regulation is more important. Whether you kind of spin it off into a separate legislation or you make significant amendments to the current legislation doesn't make a difference, right? I think all of us would agree that the effectiveness of the existing regulatory framework has to be tested if there is any question. As a practitioner, I don't have any question, and my colleagues here would agree that the current system is quite robust and it's been effective for the last 15 years. When something isn't broke, don't fix it, right? And if there is a view that the Competition Act has been ineffective, then it's important for us to identify what is the defect in it and what measure should be taken to fix it, right? And when you're talking about what measure should be taken, it is extremely important that the least intrusive and the most facilitative approach has to be taken, because you're talking about markets and products that are being conceptualized and are being brought to kind of life, right? And when and these businesses always don't have a complete plan in front of them when they are kind of conceptualizing, and that is one reason why most of these digital products are advertisement backed products, right? These are two-sided or multi-sided products where the subscription side is the least generating, right? Unless and until you've reached a certain scale, you're not able to kind of charge users, right? And that is the uniqueness or the beauty of digital markets. So when you operate in this sort of a multi-sided, uncertain market, it is extremely important to have a regulatory framework which gives innovators and which gives app developers the ability to test multiple business models before they settle in, right? That's point one. And point two, as per the low threshold that is being set now, a lot of these Indian startups might get caught, right? But what happens is the string of restrictions that are being placed, for example, tying and bundling, which is not a per se illegal conduct, right? Otherwise, in competition law, has been kind of restricted under the new draft competition bill. So what this technically does is, if a small digital player has scaled up to a certain level and they are operating at one particular product, right? You are effectively curbing their ability to enter into a related area, right? You're placing fetters on that ability. So that kind of directly hits the root of their very existence, right? If they don't expand, they perish, right? If they don't scale up, they perish. How do they scale up? They either scale up by getting more investments so that they only concentrate on one particular product area, or they kind of spread into other areas. To spread into other areas, if you're already an SSDE, right? And there'll be restrictions that are cast on that's kind of put on you, right? That kind of pulls you down from that growth path. So it's extremely important to understand what is the quantum of intervention that is required, and that cannot be a carte blanche that cuts across different markets, because as Lazar rightly pointed out, every product in a particular service is heterogeneous. The significant product differentiation, and every product, what works for a, let's say, an instant messaging service might not work for e-commerce. What works for e-commerce might not work for hotel aggregation. What works for hotel aggregation might not work for cab aggregation. So a customized soft touch approach is what is warranted. That's my lengthy answer to that first question. And I forgot the second question. If you can just repeat the second question. And Lazar has something to add here. Sorry.
Yeah, please.
If I may, very, very quickly. Yeah, totally agree with what Ramkumar said. And I just wanted to add that if you curb the ability of these SSDs or these gatekeepers, however you want to call them, okay, to enter adjacent markets, which seems to be one of the objectives of these bills, right? To sort of curb their ability to leverage that dominance to enter other markets and dominate them, right? But here's the issue is that often the companies best placed to contest other big tech's core services are other big tech companies, right? So if you curb that ability, you're maybe curbing the ability of the companies that are best placed to compete on adjacent markets where they're currently not dominant. So that's it. That's my comment.
Yeah, thank you so much, Lizard. So, Ram, the second question was, and I mean, since we are running short on time, if you can quickly address that.
Sumit, we lost you.
I think is it just me? No.
No, I think we lost him.
We lost him.
Yeah.
Okay. Here we go. No.
Yeah, he's back.
He's back.
Hey, Sumit, we can see you.
Sumit, we had lost you for about 2 minutes. So if you could just repeat that question.
Okay, so Ram, the second question, if you can quickly address that something because we're running short on time. There's a question from Mayank and Alberia. Does India have the regulatory capacity to implement such a law, specifically in relation to the CCI?
Yeah, that's a fantastic question. And I think that's one important area where the government and the CCI will have to kind of spend some energy to ramp up its existing capacity. The CCI has, though it's been doing a phenomenal job for the last 10-15 years, it is significantly overburdened. And if anything, that is the area that we as a country should be looking at, strengthening the CCI's enforcement capability, adding more professionals, giving them more, let's say, data scientists and technocrats to kind of enable them to do their job. And I mean, definitely we're not in a place to kind of take the burden. At least the CCI is not in the position to take the burden of implementing another standalone regulation.
Yeah, thank you so much, Ram. Now I turn to Laila. Laila, what are your thoughts, or I mean, what could possibly India learn from the, let us say, European experience, or for instance, even from the US, right? When we talk about this law, I mean, again, under an assumption that the parliamentary intent is clear, but yeah, what can be our learning from the EU and the US?
Thank you so much for this question. It is a very, very important question, and I would like to start by referring back to the objectives of the Digital Competition Bill, because the Digital Competition Bill pointed out that one of its aims is to promote fair and transparent dealing and non-discrimination. And as Lazar already pointed out earlier, such concepts are very abstract and very hard to apply objectively. And when we are talking about legislation, we also have to understand why the legislation is needed or what it can solve. So we can talk about this later, of course. So today, I would like to emphasize the importance of learning from international trends and understanding the pitfalls as well. For legislations like for jurisdictions like India, I think two aspects is very important. One is learning from international trends, and the other is to learn from history. So in this point, I would like to talk about the DMA. So as the DMA was one of the inspirational sources of the Indian bill, I think it's very key to point out that on the positive side, complying with one set of rules is still better for companies than complying with 27 different regimes of rules in the European realm. However, these bans introduced by the DMA and these uniform obligations in a very diverse marketplace is very, very hard for the companies, as we can already see. So probably in this sense, the UK's DMCC seems to be a smarter solution, because it tries to address the problems of uniform rules by introducing a flexible approach of individualized codes of conduct for companies. However, the dark side of this approach, that it could easily lead to arbitrary rules and arbitrary enforcement in the practice. So it's very hard to address this regulatory approach, and as we can see, different jurisdictions target the question with a very different approach. What we see at this point, the EU Digital Market Act is still a very experimental stage. It targets just companies providing core platform services, while the India has a very low threshold, and it targets lots of companies. Maybe you have numbers how many companies are affected by this bill, but definitely more than the EU's gatekeeper rules. So under the DMA, originally 6 gatekeepers has been designated. Recently, there's a 7th gatekeeper, as the Booking.com has been designated as a gatekeeper under the DMA. Regarding the original designated 6, the Commission has started the enforcement since March 7 this year, and already opened 5 investigations, as you already know, against Meta and Apple and Alphabet. So we can see that there's a high level of uncertainty and unpredictability regarding the enforcement of such laws in this very experimental stage of the DMA. And as I said, it intended to be a one-size-fits-all rule. However, these companies provide very specific services, so one size will very hard. Moreover, the DMA was very recently, since March 7, so very new, and its effects and long-term consequences are very hardly visible at this point. So what is obvious is that it created a regulatory environment that can stifle innovation and discourage companies from doing. So what can India learn from this? First, might sound, but India is the European Union. Its markets are emerging, and its startups are very. Moreover, its consumer base is largest on Earth. Thus, what might work for the European Union is not necessarily works for India or other jurisdictions. Therefore, wait-and-see approach seems to be wiser at this point. India can learn from the EU's experience, and when the time comes to adopt such laws or similar laws, it can find the best solution for its system. As Ram wisely pointed out, if something is not broken, do not fix it. Well, India needs regulatory wisdom instead of regulatory enthusiasm. So I would say that the wait-and-see approach is probably the wisest at this point.
Thank you so much, Laila. In the interest of time, Vineet, if you can quickly cover what is the larger public policy, when you talk about this new legislation in place, what could be the larger public policy of the government? If you can quickly speak so that we can also come to the conclusion.
Yeah, I mean, I'll just wrap it up as quick as I can. I think this has been mentioned again by previous speakers as well, that in many ways, the Indian government is replicating something that we've been seeing in the EU, in the UK, the FTC perhaps not with legislation, but in terms of the cases that they choose to prosecute and so on. There seems to be a larger global consensus by regulators and generally by the public, which is skeptical of large digital platforms. And so regulators or politicians have taken it upon themselves to perhaps in a paternalistic manner draft legislation which specifically targets these digital platforms. I mean, if you want the larger history of it, I think within academia, it's referred to as a neo-Brandeisian movement, which is Judge Brandeis, who originally sort of oversaw these judgments, between 1916 to I think like 29, and that first era of the Sherman Act, Clayton Act, and so on. And we are basically seeing a resurgence of that because digital platforms have largely been characterized or are perceived as like these new robber barons who control key aspects of society in terms of their control over platforms or even provision of what has now become like an essential supply, say the internet, telecom, and so on. And hence we see oftentimes what could be classified as reactionary legislation. Regardless, it it does have a lot of public buy-in. Otherwise, we wouldn't be seeing it replicated everywhere. So what we perhaps need to do is ensure that it's done responsibly. I think, again, what Ramkumar had said about the threshold, 100%, this is something that can be addressed. It's, when it comes to bundling and taking on startups who need bundling, to continue to survive. I believe that if you raise the threshold high enough and sort of ensure that it doesn't cover, startups with a 1 crore like threshold, 1 crore user threshold. It should sort of protect that industry. Again, with even when we address the bundling question, as Lazar had pointed out, oftentimes the only players who can compete with a big tech platform are players who enjoy like a dominant position perhaps in another sector. I think that this is that question perhaps has been measured out, as in, is that more likely, or is it more likely that a tech platform uses its current position to bundle and, abuse its dominant position? So I think on that side, generally around the world, lawmakers have, chosen to prioritize the latter, because there is this general suspicion around tech platforms and this, attitude that they've had, that where they bypass regulation, establish a position, and then when they have a consumer base so significant, it becomes politically unviable to regulate. And it's because of that that oftentimes the governments have adopted this ex-ante position. But yeah, I realize we're running short on time, so that's all from my end.
Yeah, thank you, Vineet. I know we have 5 minutes over the board, but I give 1 minute each to all the panelists, starting again from Pandu. What should be the way ahead? I mean, the place exactly where we are at. I mean, what would be your suggestion, and also the way forward for the government and stakeholders?
Yeah, I think we are actually doing this, circling back to what the previous regime did before this competition law came in force, like to MRTP. Refer back to what Raghavan committee has suggested then, like Lazarus measured, and then subsequently what CLRC have also like pointed out as to like current competition law regime is sufficient enough to address any any aspects of digital markets with respect to adversely affecting competition. I think we can stick to it, in my opinion. And insofar as the purpose of ex ante is maybe not sure, but could be a tech clash, an effect of tech clash, where you are not sure of right what it could be for big techs, right? And therefore, a general apprehension would lead to make such decisions. But rather, it could be an opportunity for the government or to the CCI, like they did in 2020. Many of you may know already that they have conducted a market study in 2020 and also released a market study paper wherein they have also talked about trends and features, competition issues, observations, and they also have made specific comments on self-regulations. I think self-regulations could be the key point. Yeah, have a question?
I was just saying, in the interest of time, if you can cut it short.
Understood. I think self-regulation could be the best answer at this point in time, instead of a introduction of a new legislation to deal with competition aspects of digital markets, and that too not on a ex ante. Let's have some regulations, and then look forward as to how this company is gonna react.
Yeah, thank you so much, Pandu. Lazar, if you can conclude.
Yeah, very quickly. I would say my recommendations are: stay the course with the 2002 Competition Act and with the effects-based analysis. Don't go back to the previous paradigm. Second, and relatedly, Europe is not always right. Europe can sometimes also get it wrong. Furthermore, Europe might have its own interests. Europe doesn't have many notable digital companies, and India is a unicorn capital of the world. So, take a step back and don't necessarily follow suit. Currently, only 2 countries in the world have a Digital Markets Act or similar. One is Germany, the other one is the European Union. So don't think that there is a wave that is inevitable and that you have to ride. The third is consider the costs, the error costs of getting it wrong, one, but also the enforcement costs. It's not free to enforce the Digital Markets Act. Europe could barely muster 80 people, and it needs many more. Initially, the calculus was 250 people, went down to 150. Now it's 80. But if India is going to enforce these rules, it's going to need to either build that capacity, or it's going to have to take people from somewhere else, from enforcing cartels, from enforcing mergers, to this. Is it worth it? Is this really India's priority? That's it.
Thank you so much, Lazar. I come to Ram.
I just have 2 points. I mean, actually covering 2 scenarios. The first scenario, if we feel that the current law is not working properly, let's see if fixing the enforcer, adding more resources to the enforcer, is it going to help them kind of do the investigation faster? Is it going to help the timelines? Are there possibilities of passing clearer orders, right? So those are aspects that we need to look into. And if there is a need to, after all of these testing, if we come to a scenario that there is a need for an ex-ante legislation, then this cannot be the legislation as it stands today cannot be implemented, because that tries to paint multiple different services with the same brush, which could have disastrous consequences. Even if this ex-ante has to be implemented at some point in time, there has to be specific rules for different services, and it cannot be a catch-all umbrella sort of a regulation. Thank you.
Yeah. Thank you, Ram. Laila, please.
Thank you very much. I would like to highlight 3 messages. First, see alternative solutions to cure administrative issues like long processes. It might seem common sense, but hiring more investigators or building resources could solve problems of overwhelmed offices and procedures. And sometimes we only need a little bit of common sense to make sense. Second, learn from the EU's experience on the DMA or of the TMA. And to have this, India should wait and not urge itself to a new law based on the trends instead of market necessities and market failure. Third, revise the thresholds and make it fit for the Indian market. Thank you very much.
Thank you, Laila. Vineet, please. Vineet,
Just
you're on mute.
3 points. One, I think this is everyone said, we need to add capacity to the CCI, not just in terms of people, but also in terms of the skill sets that they have. Specifically with platforms like this, you require a different type of skill set to investigate. So that. Next, definitional clarity when we create legislations like this, specifically with the SSDE title and with what we call a core digital service, etc. I tend to agree with Ram Kumar on a bill which doesn't paint all these services with one brush. We need to have different liability and different responsibilities based on their impact on said sector. And finally, I think if a bill like this is being passed, they should explicitly, I think many of my co-speakers won't, is expand the concept of consumer welfare and consumer harm to not just look at cost, but also look at impact on innovation, privacy, so on, in any legislation that follows. But yeah, that's it from my end.
Thank you so much, Vineet. I would like to again I would like to again thank all the panelists for taking time out and speaking on this key issue, which is currently emerging. We would be submitting a memorandum on this conference to the MCA. Thank you everyone for participating. And I think we can close this. Thank you so much.
Thank you very much, guys. Thank you.
Thank you, everyone.
Bye.
Thank you so much. Bye.
Thank you. Bye.